to talk to you a little bit about wills and some of the things that we probably should not put in our will, some of the things that we may want to state but that either don't make any sense or are going to create more difficulties than worth. So for instance, you don't want to put your funeral arrangements in your will. A lot of times a will is not discovered or found until sometimes days or months after a person has passed away. So it's a bad idea to put what you want to happen to you after you die in your will itself. There's a place for that, it's just not in your will. Same goes for organ donation. You generally don't list or name the organs that you want to donate or that you want your body given to research in the will itself. Generally, we don't name beneficiaries to retirement accounts in our will. Do that with the actual company that manages our retirement account, because if you do that, then whoever you name as the beneficiary of the retirement account in your will might be sorely disappointed when they find out that you named a beneficiary through the company and that the two are different. It's going to be the beneficiary that you named with your retirement account that's going to govern. It's not going to be the will in this case. You're also not going to put your end of life wishes in your will. There's a place for that too. It's called the living will. So we leave out all the things we want or don't want at the end of life in our will. We put that in a living will. Anything that you've put in a revocable living trust, you don't want to have language that says I leave the same thing in your will, because if the revocable living trust is done correctly, the trust will have control and the trust document is going to control what happens to everything. You say, well, I leave $25,000 to my niece Susie. If all of your money, all of your assets have been transferred to your revocable living trust and the trust document says something different, your niece isn't going to get that. Generally, the language involved in a will has a revocable living trust attached to it is different. We don't leave the assets that are contained in an LLC to somebody as a beneficiary in our will. The LLC is a company, and the company's operating document is going to control what happens to those assets. So you can leave your membership interest in an LLC, you can leave your shares in a corporation. You can't actually leave the assets from the business because they're controlled or owned by another entity. You can leave out the reasons why you're leaving something to somebody. If you want to tell people that you're not leaving them something because they were rotten to you in your life, they never visited you or sent you cards on the holidays, that's fine, but you should do that in a separate document, in a letter, in person maybe, but not in the will. If you don't want somebody to have something, you just leave them out. If you're concerned that they may contest it, you can add a no contest clause to your will. You can cover these things without having them in the will. And then finally, you wouldn't name a life insurance beneficiary either. So life insurance companies ask you to name beneficiaries. That's where the life insurance proceeds are going to go. It's where the life insurance company document dictates that they go. If you have concerns about wanting to name a particular life insurance beneficiary, go back and check your life insurance documents and make sure they reflect your wishes. Thanks very much, and we'll look forward to seeing you the next time.